Yes,
Good
ma'am.
morning, one and all present, and good evening to those in US. I extend a warm welcome to all the distinguished speakers who have joined us for the third annual International Conference on Comparative Law. We are extremely delighted to have with us Professor Mark Graber, Regents Professor, University of Maryland Francis King Carey School of Law, USA, Professor Dr. Richard Albert, Professor of World Constitutions and Director of Constitutional Studies, the University of Texas at Austin, USA, Mr. Philip Fergang, Founder Partner, Fergang and Edward LLP, USA, Professor Dr. Manoj Kumar Sinha, Director, Indian Law Institute, New Delhi, Ms. Priya Kumar, Advocate, Supreme Court of India, New Delhi, and Dr. Nasiruddin Mohammed, Faculty of Law, University of Dubai, Dubai. I do know that it is quite late for the speakers from USA, so without any delay, we would be starting the session. Firstly, I would be calling Professor Graber, who is a recognized leading scholar on constitutional law and politics. He's the author of a new introduction to American constitutionalism from Oxford University Press and a co-editor of American Constitutionalism, Structures and Powers, and American Constitutionalism, Rights and Powers. He is presently working on Forged in Failure, a book that will examine how much constitutional change in the United States has been caused by the failure of the constitutional practices to function as expected. Professor Graber has written scores of articles on constitutional law. He's been the organizer of the annual Constitutional Law Smoosh, which attracts scholars from across the country to the law school. He's also a visiting faculty member at the University of Virginia School of Law. I now call upon Professor Graber to address the session.
Well, thank you very much for a very kind introduction and an even kinder invitation to speak to all of you from my basement and fuzzy television picture. Now, one of the central topics of comparative scholarship across the world is the rise of populism. And it's rather interesting that when we talk of populism, we often don't do a whole lot of comparison. Rather, there's a sense in the literature that all populists look alike. The populist movement in Poland is the populist movement in Hungary. We have chapters on India, and the great people say, see, India, the populists there, they're like Orban, like the PIS, like Trump in the United States. There's a very good book by Mark Tushnet and Bojan Bugarik that points out that not all populists are alike. Some populist movements are authoritarian. Some populist movements are far more democratic. I will leave to you in India to decide where and which column your populist movement goes to. But I want to suggest there's another way in which not all populist movements are alike. So a very standard approach to populism is populists get in power, and the first thing they do is either change the constitutional text or dramatically change the people interpreting the constitutional text in ways really not encompassed by the rules. So either the Constitution gets changed or the judiciary is overwhelmed. And I want to suggest the United States under Donald Trump may have been different. Tocqueville once described the United States as born equal without ever having to become so. Lewis Hartz, a great scholar of American political development, said, here's an important consequence of that. He said, European liberals faced entrenched powers, an entrenched nobility, an entrenched church. In order to overthrow the nobility and the church, they needed a powerful state. And so, in fact, European liberals in the 18th and 19th century became statists. Americans who were born equal, when we came to the United States, it's very much a settler regime. But the settlers did not see an entrenched church. There was not an entrenched aristocracy. To be a liberal society, you didn't need a powerful state to overthrow status hierarchies. And indeed, in the United States, the state has probably been more of a source of status hierarchies than something that overthrew them. So American liberals liked a small state. So I want to suggest today that certain features of the American past explain why many American populists have a very different attitude towards the Constitution, the existing Constitution, than many populists in other regimes. In particular, populist movement in the United States is very much committed to a philosophy called originalism. Populists claim that they are interpreting the Constitution according to its original meaning. The hero of legal populists in the United States is Justice Antonin Scalia, who claimed all he did when interpreting was channel George Washington, Thomas Jefferson, James Madison, and people long dead who wore funny wigs and owned slaves. The Reagan administration claims similar. The Trump administration claims similar, that rather than seek to overthrow the Constitution, they sought, in their words, to restore it. Now, this is rather unique to Americans. Other populist movements are not in to constitutional restoration, in part because the United States Constitution is rather old, which we'll get into. Constitutions around the world are typically quite younger. So your Constitution is 1948 or around 1948. And I apologize for misstating even very basic facts about your Constitution. The Hungarian Constitution was the 1980s. The Polish Constitution was from around there as well. And those constitutions were written by liberals, by progressives, by people who were still alive. The result is, when populists challenged Hungarian progressives, they were challenging the Constitution Hungarian progressives wrote. They had to change that Constitution. They couldn't say, we want to interpret that Constitution as the framers interpreted, because everybody knew the framers didn't like them. But Americans have a different story. Now, this is not to say originalism is very, very neat. To begin with, there are all sorts of general problems with originalism, which essentially ask, what would the framers do if they faced our problems and had our conceptual apparatus? The right answer to that question are things like James Madison could not conceptualize the internet, and trying to figure out what he would do with the internet is an exercise in futility. Moreover, it turns out lots of history is not that supportive. Most populists claim to support locals against cosmopolitan elites. Problem is, framers of the United States Constitution were cosmopolitan elites who very much didn't like the locals. So one solution is simply very, very selective history. Take quotations out of context. In that way, in some ways, you are defying the Constitution, but you're doing so in the name of the Constitution, and one must wonder, why bother with the exercise? And here I think the answer is, in part because the Constitution is old, the Constitution plays a special role in American constitutional identity. If you want to know who real Americans are, they're the Americans who wrote the Constitution. They're our framers. One becomes a real American by identifying with those framers. Whereas for many populists around the world, the authors of the most recent Constitution betrayed the people. The Constitution is not the work of the real people. We need a new Constitution. We are justified in throwing away this Constitution, discarding it even by non-constitutional means, because this Constitution was not written by the real people. So in the United States, the framers of the Constitution are good. They are the real people. Other regimes, the framers of the Constitution, sometimes they're simply bad, sometimes they're mediocre, but movements do not simply say what we have to do is restore the original Constitution. Sometimes they say we have to restore the people. But the people are distinct from the Constitution in most populist regimes in a way that they're not in the United States. Second feature and a great advantage of old constitutions is no one knows much about the Constitution. Americans sort of know that George Washington was around, but who really knows what the purpose of the Second Amendment was, the right to bear arms? Now, it could be there are actually 17 professors of legal history who have something intelligent to say about that. But in this world of the internet, of I'm an expert if I know how to blog, those 17 professors occupy almost no space. If we operate on the assumption, A, the framers are good, B, the framers are the people, C, I am good, I embody the people, then it follows the framers must have thought the way I thought. Whereas for a great many countries, either the framers are still alive or somebody who knew the framers are still alive. There's a wonderful scene in a Woody Allen movie when Woody Allen was considered funny in the United States, where he is on a movie line and somebody near him is making comments about Marshall McLuhan, who was a prominent American thinker. And all of a sudden, it turns out that Marshall McLuhan is online and says, "You don't know what you're talking about." Well, framers of the Hungarian Constitution are on the movie line, but George Washington isn't. Nobody can refute statements about Washington. Moreover, again, one feature of new constitutions, and one reason why in the United States we might want to consider a new constitution, is new constitutions talk about contemporary problems. New constitutions talk about the environment. New constitutions talk about rights, reproductive freedom. I was having a conversation with a student a couple of hours ago and commenting that one of the real challenges coming up is teaching the rights of transgendered people, because obviously a constitution framed in 1787 and most significantly amended in 1868 isn't going to talk about transgendered rights. And indeed, it is only a constitution framed in the last 5 to 10 years that is likely to talk about that. But because the Constitution does not talk about a lot of the new rights that have been developing, it becomes entirely possible to say what they did not imagine, they did not sanction. Now, it turns out there are very good constitutional arguments that say, properly interpreted, the 14th Amendment supports same-sex marriage. But there is a certain populist thing to say, they weren't considering same-sex marriage, therefore it is not protected. So in short, populists in the United States have a whole range of arguments available to them to say, we don't have to change the Constitution an iota. Indeed, you radicals who want to change the Constitution, you are the ones unfaithful to the people, unfaithful to the Constitution. We are the true constitutionalists. These arguments are far less available to populists in many other regimes, and we might talk about how well they're available to people in India and people in the country that many of you represent. How much, I tend to go over. How much more time do I have?
We've got around 2-3 minutes more.
2 to 3 minutes. Okay, that's all I need. I promise no cliffhanger ending. I'll simply note a second feature that the Republican Party, which is the more populist party of the United States, has for the past 30 years made slow inroads in the judiciary. By the time Donald Trump became president, about half the judges were Republicans. So again, what was required was not a wholesale restaffing of the judiciary, but simply maybe a more intense politics as usual. Delay Democratic nominees, rush Republican nominees, all consistent with the word of the Constitution, if not necessarily the spirit. So again, whereas in Poland, new rules had to be made about the judiciary for the PIS party to control the legal system, minor tweaks had to be done in the United States. Again, it is the non-populist party talking about radically changing the judiciary. In short, we do need to be comparativist about populists. As Mark Tushnet points out, not all populists are authoritarian, some are Democrats. But even within the authoritarians, they seek power in countries with very different traditions and constitutions. And my argument is, we need to know, how old is the Constitution? Who is it identified with. What is the relative control of the judiciary, and whether populists are originalists, whether they write new constitutions, what they do with the existing judiciary depends on what they did or what was done before. That again, history is a motion picture rather than a snapshot. Thank you very much.
Thank you, Professor Graeber, for bringing in a new dimension to the understanding of Constitution. Thank you so much. Now, our next speaker is Professor Richard Albert. He is a professor of world constitutions and director of constitutional studies at the University of Texas at Austin. A graduate of Yale, Oxford, and Harvard, he has published over 20 books on democratic reforms and constitutional values, including constitutional amendments, making, breaking, and changing constitutions, published by Oxford University Press. Professor Albert is co-president of the International Society of Public Law, the founding director of the International Forum on the Future of Constitutionalism, and a former law clerk to the Chief Justice of Canada. I now invite Professor Richard to kindly address the gathering.
Well, thank you very much. A constitution and rules for its amendment are like a lock and key. One cannot work without the other. And so it's no wonder that amendment rules appear in virtually all of the world's constitutions, over 96%. Yet, despite their importance, we know very little about the rules of constitutional amendment. How do we design them? What are their functions? What are their theoretical underpinnings? And what are their limitations? These are some of the questions that interest me and that I hope will also interest you. And I'm going to address some of these questions today in my remarks entitled Constitutional Amendment and Dismemberment. But first, let me say thank you. Thank you to the conference organizers at Amity University and Edith Cowan University, especially to Drs. Parashar, Singh, and Tomer. Thank you to the moderator for this session, Dr. Matthew, to my fellow keynote speakers, and to all of you in attendance. Reformers all around the world are exploiting the forms of constitutional change and testing the limits of law. They're openly engaging in what one scholar described at the height of the Second World War as fraude à la Constitution. Translation, constitutional fraud. There's growing evidence around the world that leaders are looking for ways to extend the life of their constitutions beyond their natural lifespan. Rather than mounting an effort to create a new constitution when the constitution has outlived its scope and purpose, leaders instead all around the world turn to the procedures of constitutional amendment to transform the Constitution into something completely unrecognizable. These changes are often called constitutional amendments. They're presented as amendments, and they're enacted using the procedures of constitutional amendment. But these changes are not amendments because they are amendments in name alone. Let me give you some examples. In Brazil, the public spending cap limits public health spending on health, education, and other areas of social welfare. It was an amendment passed to address the country's increasing budget gap. This constitutional change, as I mentioned, was enacted as an amendment, yet it violates the core constitutional commitment in Brazil to maintaining a social state. It undermines social rights in the country, not only in this present generation, but for many generations to come. That is not what an amendment should do. It should not violate a core commitment made by the Constitution. Let's now move from the Americas to Europe. Come with me now to Albania. In 2015, the country engaged in a massive constitutional transformation that yielded a new constitutional court, a new high judicial council, a new declaration of values, and an entirely new conception of democracy. This change was enacted as a constitutional amendment, but its effect on the polity was much greater than one would expect of a simple amendment. And now come with me from the Americas to Europe, now to Asia. Turkey in 2017, its constitution was transformed from a parliamentary system to a presidential system. And this new system gave virtually unlimited powers to the president. It's a big change from the previous system, which required parliamentary forms of decision-making. This constitutional reform also reduced the number of constitutional court judges. There were tens and tens of alterations to the text of the Constitution in this single constitutional change. This was a huge transformation of the Constitution. Each of these reforms in Brazil, in Albania, in Turkey, and beyond, each of these was called an amendment. Each of these was enacted as an amendment. But each was much more than an amendment. It was not a simple amendment. One way to visualize the magnitude of these reforms is to think of an apple. The reforms in Brazil, Albania, Turkey, and elsewhere are the equivalent of removing the core from the apple. The apple survives, but the apple becomes something much different, unlike what it was prior to its core being removed. It might not even be fair to still call that thing an apple. A constitutional amendment should not remove the core of the Constitution. It should keep the Constitution intact. And so we need another term, another concept to describe a constitutional change of that scale. We need a different concept to understand the scope of these constitutional reforms in Brazil, in Albania, in Turkey, and so many other countries around the world. And so the question now presents itself. What were these constitutional reforms in Brazil, Albania, Turkey, and elsewhere? What were they, if not constitutional amendments? I'll answer that question. But first, we need to define what an amendment is. An amendment, properly defined, is a kind of a constitutional change that has four fundamental features: its subject, its authority, its scope, and its purpose. An amendment is an authoritative change to higher law that corrects, elaborates, reforms, or restores the meaning of the Constitution consistent with the Constitution's existing framework and consistent with its fundamental presuppositions. Sometimes amendments are enacted using special procedures, sometimes not. But in all cases, an amendment, in order to be an amendment, has one overriding feature that matters more than all others, and that is the scope of the change. The amended Constitution must remain coherent and consistent with the pre-amendment Constitution. Because properly defined, an amendment continues the Constitution-making project in line with the existing design of the Constitution. An amendment entails unbroken unity with the Constitution being amended. An amendment improves on the Constitution's design where necessary or useful to align expectations about how the Constitution should function with how it actually does function. But in all cases, an amendment does not push the boundaries of the Constitution any further than its outermost limits. That is an amendment. That is what a constitutional amendment is. Now back to the reforms in Brazil, Albania, Turkey, and beyond. Those changes were called amendments. They were proposed as amendments. They were enacted as amendments. Yet, I have insisted to you that they are not amendments. And so the question now presents itself. What are those changes, if not constitutional amendments? Well, those changes are constitutional dismemberments. Constitutional dismemberments. A constitutional dismemberment removes the core from the Constitution. It transforms the Constitution in a significant way. A dismemberment of the Constitution does violence to the existing Constitution because it destroys one of its essential features. A constitutional dismemberment has four fundamental features. It is a constitutional change that is incompatible with the existing framework of the Constitution. It seeks to achieve a conflicting purpose, a different purpose than the existing Constitution seeks to achieve. It entails a fundamental transformation of one or more of the Constitution's core commitments. For example, the identity of the Constitution, the fundamental rights in the Constitution, or the structure of the Constitution. It intends deliberately to disassemble one or more of a Constitution's elemental parts. And so, to use a rough shorthand, the purpose of a constitutional dismemberment is to unmake the Constitution. There is one final distinguishing feature of a constitutional dismemberment, and this is a critical point. A dismemberment is a descriptive idea, not a normative idea. A constitutional dismemberment is not necessarily a bad thing. It can lead to good outcomes, just as it can lead to bad outcomes. It's a neutral concept. And so we can talk of the American Reconstruction in defense of liberal democratic values as a dismemberment of America's slavocratic constitution. We can also speak in the same breath of the transformation of the Hungarian constitution today from what it was before, a liberal democratic constitution. Both are examples of constitutional dismemberments because the point is that a dismemberment is a transformative constitutional change that exceeds the boundaries of what we define as an amendment in a particular constitution. We've seen dismemberments all around the world. In the Americas, in Africa, in Asia, in Europe, in civil law countries and common law countries, in presidential regimes and parliamentary systems, in the global South and global North, everywhere. It's a common phenomenon. I see that I have about 3 or 4 minutes left. And so let me just end with a question. What's the relevance of this distinction between a constitutional amendment and a constitutional dismemberment? Well, it's relevant for constitutional design, specifically in how we design the rules of constitutional change. The concept of constitutional dismemberment suggests that amendments should be enacted with a lower threshold of approval than should be required for dismemberments, which should be enacted only with a higher degree of approval, whether that be from the people, legislatures, a combination of the two. And let me explain why. A major problem today around the world is that reformers are routinely enacting constitutional dismemberments using the procedures of constitutional amendment. They should not be permitted to do that, because an amendment is a small-scale change to the Constitution, while a dismemberment is a large-scale change to the Constitution, and there should be different procedures for each. Easier procedures for amendments, because they're smaller changes, and harder procedures for dismemberment, because they're transformative changes. And so think of a hierarchy of constitutional rigidity. At the low end of the scale of constitutional importance, it should be relatively easy to make changes to the Constitution that do not transform the identity, basic structure, or rights in the Constitution. Those are amendments. At the high end of constitutional importance, it should be very difficult to make changes to the Constitution, because those changes are the ones that will impact the most important core features of the Constitution. Those changes should require higher thresholds of approval and ratification, a greater depth and durability of agreement, and more points of entry for popular deliberation, popular input, and popular consent. That should be the path to enact a constitutional dismemberment. You can have 3 different procedures of change, 1 for amendments, 1 for dismemberment, something in between. You can have 4 procedures, 5, even more. The point is that there should be a distinction between what is used to amend the Constitution and what is used to dismember the Constitution. And one last point. How do you distinguish between which parts of the Constitution could be changed by amendment procedures and which part could be changed by dismemberment procedures? How do we decide that? Well, the choice about what rule or principle of the Constitution requires which threshold of change, that choice is to be made by the designers of the Constitution at the period of constitutional creation. There aren't many examples of constitutions that take this approach. Austria, Canada, Ecuador, Spain, Switzerland, there are a few others. But the scarcity of the examples, to me, reinforces the general point, which is that to its detriment, the standard design of constitutions does not recognize the distinction between amendment and dismemberment, and it should. It should because it leads to greater stability. It leads to greater legal stability, legal continuity. It avoids the non-trivial risk of failure in the effort to create a new constitution. And so that's why I propose this escalating structure of constitutional change, because it delivers the advantages of clarity, predictability, as well as transparency. And so let me close once again by just saying thank you to the organizers for inviting me to participate in this third annual International Conference in Comparative Law. Thank you to Amity University, Edith Cohen University, Doctors Matthew, Parashar, Singh, and Tomer, and to all of you. I look forward to seeing you again, perhaps next year at the 4th edition of this important conference. Let me just now close with my contact information. If any of you in the room would like to be in touch about the work that you're doing in the area of constitutionalism, or specifically constitutional change, here's my email address and contact information. I'd be very happy to hear from you and to read your drafts. I'd love to learn from the work that you're doing. And finally, if you'd like to read a bit more about the ideas that I've developed in my remarks today, here is something that I've written, and you're free to use it for academic purposes. And I look forward to being in touch with all of you. Thank you once again for having me.
Thank you, Professor Richard. It was an awe-inspiring lecture, and you have brought in new ideas in terms of constitutional amendment and also with regard to constitutional dismemberment. Thank you for your address. I would now like to invite Professor Dr. Manoj Kumar Sinha. He is the Director, Indian Law Institute. His areas of specialization includes human rights, constitutional law, international humanitarian law, international refugee law, international criminal law, and international institutions. He has published extensively, and he has authored and edited books like Intellectual Property and Human Rights in India, Law of Sedition in India, Freedom of Expression, Emerging Competition Law, Copyright Law in Digital World, Challenges and Opportunities. He also serves as a member of several editorial boards of several reputed national and international journals, and he was a visiting professor at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Sweden. I now invite Professor Manoj Kumar Sinha to address the gathering.
Thank you very much, Professor Jain, Professor Robert, Professor Mark, Priyazi, Sakshi, and all others present here. It's a great learning process for me after hearing Professor Mark and Professor Richard. And I'll discuss something on the constitutional amendment also a little bit later. When comparative law or comparative constitutional law we look into, so as a teacher, I try to attempt. So there are two approaches which I feel very much needed to be applied in a classroom teaching and scholarly writing. So the two distinctions we have to make in the when we go in the class, we have to focus more on the fundamentals of the particularly on the constitution and the comparative constitution or comparative public law, whatever it says, so distinction has there. So a student carry forward. And that is keeping in the mind, I structured my talk on the 4 or 5 important points, and where I see it's important to know about the system or constitutional governance in the respective other countries when we teach constitutional law in India and any other jurisdiction. We heavily take note of the US Constitution. That is the like West, particularly when we go into the classroom, or US Constitution is like, primary source of comparison when we enter in the classroom. Let me highlight the structure of my talk, which I focus, and how it changes also when we enter in the academic discourse like this, where our perception also shifts, understanding also enhanced how we have to structure our lecture or our writings also. So first, I think federalism, I will start with the federalism, doctrine of separation of power, relationship between union and states, emergency provisions, and the civil political rights and economic, social, cultural rights. These are the first 6, 7 points we have. So when we go into the constitution, the class of, when we start federalism, it's it started with decentralization. We speak about the decentralization, and we try to compare between the Indian Constitution and also the United States Constitution. We start with the conceptual confederation and then federation. So we see the United. So the very important thing, we look into the Canadian Constitution, Australian Constitution, and of course under the United States Constitution, and we see. So we have a challenge also when we look into the Indian Constitution, whether it's a truly federal constitution or it has some kind of mixed, both federal and unitary. When you look into the Constitution, starting with the Article 1 of the Constitution, which clearly states India is a union of states, and then we try to examine. So in that context, it's very important to know about the comparative perspective, to different perspective from different constitution, which we heavily do that. In that federalism, recently we had a talk, and where we have when we talk about the federalism and types of federalism, then we have a cooperative federalism becomes very fundamental and very important, cooperative federalism. So recently we invited a scholar from the Canada, Indian origin scholar from the Canada, and to speak on the cooperative federalism. And when we started, she entirely changed our perception. We agreed and somewhere we disagreed also, but she changed, the cooperative federalism, what she started with, the entire exercise, how the constitution of the democratic states are shaped today, it's not through the internal mechanism, it's a highly influenced by the external mechanism, external institution, external economic institutions, particularly economic institutions when we talk about. So International Monetary Fund, the World Bank, and other organizations are an agenda. They have their own agenda, which directly or indirectly shaping the constitution, not the Indian constitution, but some way it also impact, but newly independent states like the states which have come into existence after the decolonization process, which started in 1960 onwards. So 1960 onwards, number of African states started changing their, they got independence from the colonial rulers and they started. So they say the International Monetary Fund and World Bank, they market-oriented approach in the constitution. And so cooperative federalism, what she said, this is very important, and one has to look into the constitution where market-preserving federalism, an article has been also written by one of very important professor from the Stanford University, Barry H. Instott, on the market-preserving federalism. That interpretation. So when you look into how the international economic institutions also play very important role in the shaping of the constitution. And particularly, when we look into the philosopher of the cosmopolitanism, Professor Thomas Pogge and others, Michael Charles Beach and others, they emphasize, they have talking about there is a global basic structure doctrine. So basic structure, we have the constitution, but they say, there is a global distributive justice. There is a global basic structure. So now a time has come, we have to look into the more in the holistic manner in the interpretation and application of the constitution, where a lot of developments has taken place, both by the international institution and also the perspective of the cosmopolitanism. And we see interdependence have increased hugely worldwide, and accordingly things have been changing. And if we see in the particularly in the context of economic, like after WTO has come into existence, a huge changes has taken place in the national level in almost all the member states of the World Trade Organizations. Going ahead, moving ahead after the federalism, we go to the doctrine of separation of power. When we talk about the separation of power, we compare with the United States, United Kingdom, and the Indian scenario we look into. When we talk about the separation of power, we see the US model is more rigid. Like, that's a clear-cut division of separation of power exists in the US model. Whereas in the context of the United Kingdom, we look into the parliament, sovereignty of the parliament, which has also been restricted when the United Kingdom was a part of the European Union, so it has been limited, but supremacy of the parliament is there. But when we come back to the Indian, we see the constitution is supreme. Constitution is supreme, and judiciary has an important role play to interpret and apply the principles of the constitutional principles from time to time in the Indian scenario. So we have a mixed one. So like, we compare. So comparatively becomes very important in the classroom. When we enter the classroom, the understanding of the separation of power, why it is important. And we also go to the Montesquieu. That is like, the separation of power. So Montesquieu says, so that particular thing is very important. Then we look into the relationship between union and states, and various aspects we examine from the different perspective. Most important, which I feel in today's context, the emergency provisions and fundamental rights. Emergency provisions and fundamental rights. We see that recently, just 2 or 3 days back, for 30 days in the state of Canada, emergency has been imposed because of the freedom convoy or strike by the truckers. So like this is I believe this is the second time emergency has been imposed in the state of Canada, and this was the second time. The first time, what I read in the newspaper, I have not gone in deeper. It seems that father of the Tordoy, he imposed the first time emergency, and this is the second time emergency has been imposed in 30. So we see, but when we apply the emergency provision under the Indian Constitution, and to understand the strength of the Indian Constitution, particularly when we go to the in the 26th June 1975 to March 1977, we have series of things, and we see how fundamental rights were made almost irrelevant in time of a state of emergency, particularly by the ADM Jabalpur versus Sifkan Shukla case. We have looked into how the emergency and also 42nd constitutional amendment. If I say the 42nd constitutional amendment, which inserted clause 4 of the article 368 under so under Professor Richard, so we have article 368, which laid down the constitutional amendment procedure. So what 42nd constitutional amendment? So a lot of things we discussed, but constitutional amendment, 42nd constitutional amendment, which has been subsequently after the Minerva Mill judgment and also Woman Raw judgment, has held unconstitutional. So what the 42nd constitutional amendment inserted clause 4 of under article 368, which established the supremacy of the parliament and ousted the jurisdiction of the power of the judicial review of the court by the article 368 clause 4, which has been subsequently held in the landmark case in Minerva Mill unconstitutional. That has gone, that is no longer there. But you see the attempt by the so there was a continuous struggle in Indian scenario. When we look into the Indian scenario, there's a continuous struggle between the supremacy of the judiciary and the parliament. So this was the attempt in the article 3 in the constitutional amendment, in the 42nd constitutional amendment. But constitutional amendment, 42nd constitutional amendment has also some good aspects. Also, this 42nd constitutional amendment has inserted the part 4 of the Indian Constitution, that is the fundamental duties, which has been added under Constitution. And however, the constitution, through the constitutional amendment, we see a lot of changes. So like, the journey, if I start from the first constitutional amendment, and particularly if we end with the 44th constitutional amendment, we see the continuous tussle between the judiciary and parliament regarding whether part 3 of the constitution can be amended or part 3 cannot be amended, or basic structure doctrine. A series of development has taken from the 1952. I end there in 1978. So if I start with the 1958, 1950 onwards, we see the first constitutional amendment. In the Indian scenario, what we see. So what is important? What is important when we discuss about the constitution? So it's like, it has to change according to the, so living constitution, organic, so Indian constitution and other constitution, there's no need of the completely substitution of the constitution, but constitution should have a mechanism to take note of the changes of circumstances, in time, and which keeps on changing according. So that is the, it should not be very textual, originalism, originalism and living constitution, they're two important theories we interpret. So it should not be static. It should change according to the time, and which, in Indian scenario, we look into, we witness it has, according to time, it has shaped by the honorable courts in the Supreme Court and High Court, time to time, it has been added. So we come back to the first constitutional amendment. So the first constitutional amendment, there are a lot of land reforms and other issues were involved. So they, by first constitutional amendment, a 9th schedule was added in the in the constitution, and it says any legislation, if you put in the 9th schedule, it cannot be subject of judicial scrutiny, and that continued. But of course, in the Vaman Rao and subsequently in Iyer Coelho, the court has said that it can be also examined the 9th schedule. That is there. Then after the first constitutional amendment, we see the another important and this was upheld. This was upheld by the 2-3 judgments of the Supreme Court of India, that is the Shankari Prasad case, Sajjan Singh case, and subsequently also in the that has been overturned by the Golaknath case, where says no, the fundamental rights cannot be amended, and subsequently in Keswanand Bharati, what we say, it can be amendment, but basic structure doctrine has that basic structure doctrine cannot be amended of the constitution. So we see in the constitution, what Professor Robert has mentioned, our constitution in a way very progressive, and of course judiciary plays very important, and that is why it's become very important to understand the constitutional values, constitutional principles, constitutional goals in comparison with the other constitution. What I suggest, the next step we should have, what we are doing, we are going more on the Western constitution, and we are more going to the towards the West when we look into the constitutional perspective. Time has come also to understand our own areas, our own continent. Largely, we need to look into the how constitution, particularly in the are effective in the Bangladesh, Nepal, Afghanistan, Maldives, Bhutan, and of course Asian countries, Southeast Asian countries, South Asian countries and Southeast Asian countries. We are a lot of things we have a common, lot of things cultural, religious, and other aspects are there. We need to also examine. So next time, if Professor Aditya, so I say we look into the scholars must examine. Particularly, we can go into the South Asian perspective and try to see the constitution, comparative constitutional, not only on the classroom and also beyond on that particular. Just to last point, which I have, that a new dimension, which after South Africa became from apartheid, and South African constitution, and a very good article written by the Professor Carl A. Clare. Carl A. Clare, he wrote about the transformative constitutionalism. We talk about the transformative constitutionalism. And Professor Carl A. Clare, so he actually started transformative constitutionalism, which also we regularly refer in the Indian constitution sense also. So he wrote an article on the legal culture and transformative constitutional. Carl A. Clare. So he's the father, Carl A. Clare. He wrote an article on the legal culture and transformative constitutionalism, which was published in the African Journal of Human Rights in 1998. Karl Leclerc. So he talks about so when we talk about the transformative constitutionalism is very important principle where implementation of socio-economic and other things. So we make comparison, even in a number of cases, court has used the transformative constitutional. So a lot of development is there. We live in a world today where interaction among the nation states are much higher compared to the 30-40 years back. So interdependence have increased. Integration of the nation states have increased significantly. So all aspects, constitutional and even on the other aspects, are equally important to understand and have some kind of uniformity when it comes to the respecting the sovereignty and territorial integrity of the state. But certain principles should be imbibed. We can learn from each other, whether from Canada, from the United States, from Bangladesh or Pakistan, learn and see that our people's rights are respected and their human rights are respected and fulfilled. With this, I end here, and thanks Professor Aditya, Professor Sakshi, and Professor Jain. Thank you very much for a wonderful opportunity. Thank you. Over to you.
Thank you so much, sir, for a thought-provoking address on various facets of the Constitution. Thank you so much. Now, I would like to invite Ms. Priya Kumar. She's a practicing counsel with 25 years of experience. She regularly appears and represents clients in different forums, including the Supreme Court, Delhi High Court, and other high courts and forums. In addition to representing clients before domestic and international arbitrary tribunals, she specializes in alternate dispute resolution with a special focus on infrastructure arbitrations. She has handled arbitration and resulting litigation in respect of some important infrastructure projects such as national highways, sports stadiums, airports, and hospitals. Now, I would like to invite Ms. Priya Kumar to address the gathering.
Thank you, Dr. Matthew. Thank you for the opportunity. I really am grateful to Amity and the organizers for giving me this opportunity of putting across my views as a practicing advocate. I am humbled to be part of this very distinguished gathering where I find I'm in the company of some very accomplished academicians. And I would just like to put my view across as what I bring from my experience of practice. Dr. Matthew, with your permission, can I just take a minute to respond to, add to what Dr. Richard Albert stated? I would just like to respond to that if you just give me permission for it.
Yeah, sure.
Yeah. Dr. Albert, you will be, I don't know whether he's around, but I would just like to add, he started a very interesting conversation of what is constitutional amendment. I will just take a minute on that to tell you that way back in 1973, the Constitution Bench of India said that there is a basic structure of the Constitution which you cannot change. And they struck down laws which they found, and they've been doing that consistently, that they say that there is a basic structure, there is a core you can't touch. Professor Sinha touched upon it and gave us an insight into it, but I was just too excited to let this pass. So I must give it to, I must convey to you that way back in 1973, our Supreme Court was conscious, and they are repeatedly insisting that there is a basic structure which you can't touch. And we are guarding the Constitution like nobody would. So with that, I would just like to add to that, and I'll now move on. I really bring in the business perspective. I bring in a business concern in my address today. And what I am addressing is a little of a divergence from a very important issue that has been raised of Constitution, but I bring in a business concern as to finality of alternate dispute resolution. Alternate dispute resolution has come in as a concept of ensuring speedy and quick justice reaching parties. And therefore, it is important for the business to know, because business is what runs economies, and economies ensure that we all live a good life. And therefore, one concern that has led that we should have some finality in alternate dispute resolution. You take away the dispute resolution away from courts, but if courts are going to interfere again, what is the finality to that resolution? There is a concept of party autonomy, and that is where alternate dispute resolution comes in. That is, you give an alternate forum to the parties to decide that this is going to be your resolution forum. You choose the person, you choose the procedure, you choose the law, and within the framework of national and international boundaries. Now, what is the finality attached to that? Are the courts going to come back and keep reopening the product of such alternate dispute resolution? Now, that is the subject of my talk today, and I believe I have about 11 minutes to go. So on that, I am actually concerning myself. I'm kind of going to be dividing. I'm going to take my journey from a very basic thing. What is the first doorstep for a court to interfere? Do we, in a very innocent manner, allow the court to enter into a product of alternate dispute resolution and arbitration award? Now, I find I am going to restrict myself to the Indian Arbitration Act, which is called the Arbitration and Conciliation Act of 1996, which is modeled on the UNCITRAL model of 1996. So therefore, that is a product of the UNCITRAL model. But I'm going to look at the Federal Arbitration Act, which is of 1925, and I found it very interesting that it hasn't changed from 1925. Of course, it's been supplemented and it's been brought up to the current scenario. But I'm going to compare the two. The reason why I picked FAA is that though FAA only deals with certain limited issues of commerce between states, maritime, but it still is the overreaching thought process that is prevalent in America. I believe the states have their own regime and own laws, which is, they have a fair amount of independence. But I am only because there's limited time, there's limited concepts that I'm looking up. So therefore, I'm comparing the FAA with the Indian Arbitration Act. And I find that there are three issues on which there is a lot of interchanging, a lot of parallels, a lot of commonality, which I'm going to put before you. The first issue is, which is the first doorstep of interference of court in arbitration award, a product of party autonomy and alternate dispute resolution. And that is correction of an award. There is a minor error in the award, a clerical error, a typographical error, a calculation error, error of party description. Now, in FAA reserves that right for the court. The court can do it, that's section 11. Interestingly, the Indian Act, which is 1996, and we are going through a lot of amendment very, very frequently, and the latest being 2019. The Indian Parliament said, no, we will not give you this window. We will not allow the courts to jump in from the window and start looking at what the arbitration awards are. The Indian statute, the Arbitration Act, says any correction, typographical, description of party, or of any kind will go to the arbitrator. He will decide whether there is an error at all. And the parties have a time of 30 days to go back to the arbitrator and say, well, we find that these are the errors in your arbitration, kindly correct that. So in my opinion, as a professional, that's actually not even a window open, not a door open. You cannot enter that. So therefore, I feel that may be a more prudent thing, because even the most disciplined judicial mind, the moment it gets into the merits of an award, by any reason, because if there's any correction, if it's contentious, if there are parties who are contesting that correction, the court gets a window to get into it. The Indian regime closes that. The second aspect that I'm dealing with is saving the award. In that, I find that the Indian thought process and the FAA are quite similar, though of course the Indian Arbitration Act provides much greater opportunity to save the arbitration award. The first opportunity is, as I mentioned, you go back to the arbitrator to say, well, you made a mistake. Party autonomy, if the parties consent, or their agreement provides, or there is a consent letter, they can even go back and say, well, we feel that your explanation is not clear. Can you give an interpretation of the specific point? They can even invite the tribunal to give an additional award. That is to eliminate any grounds for setting aside. In fact, our Chief Justice very recently in a judgment of Dyna Technologies cautioned the parties that you must do this more often. And I quote from what he said in the judgment: you must have a clear award rather than to have an award which is muddled in form and implied in its content, which inevitably leads to wastage of time and resources of the parties to get clarity in some cases, frustrate the very reason for going for an arbitration. So it provides an opportunity for the arbitrator to give clarity of his own, saves the arbitration award. The second opportunity is, in the Indian context, is Section 34, where in Section 34 is the provision whereby the court can interfere into a challenge of the award. And at that stage, the arbitrator, the court can send the issue back to the arbitrator to say that, well, I see a ground for setting aside, but there is an opportunity for you to correct it. And that is the second round where an arbitrator can set right, erase the ground for the award to be set aside. The last opportunity is for the court to save. Once the matter comes to the court under a challenge procedure, the courts in India are empowered to sever the offending part and save the other part, provided you can sever it out. So I find a parallel in FAA. In FAA also, though the first two stages are not there, the last stage is there, that if the court is considering a situation where it is looking at vacating an award, or a vacatur as they say, is they can sever the part which they think is offending and retain the other, provided that severance is possible. So that actually gives me a lot of hope that the global issue is that you must save the product of an alternate dispute resolution, party autonomy. And the last section that I'm dealing with, since I'm left with about 4 minutes to go, is the authority of the courts to actually interfere. Now in India, we have ad hoc arbitration. When I say ad hoc, I mean even when you're within an institution, it is largely procedural support and procedural issues which are dealt with. It is not the kind of institutional arbitration that we see in more evolved economies, more evolved countries, more developed countries like America or Europe, US, England, or even SIAC experience in Singapore. But by a constitutional amendment, the Indian Arbitration Act has incorporated institutional arbitration. Though that is still not enforced, we're still dealing with putting systems in place. So as of now, we continue to have an ad hoc arbitration. And in that, the courts have very reluctantly, and I must say as a practitioner, courts in India are very reluctant to interfere with even domestic awards. They do not wish to tread into a path which is not theirs. But at the same time, invested with the duty to do justice and within a framework of public policy, the courts have identified certain grounds in which they would like to interfere, not because they're judging the arbitrator, but they are judging the system of justice. They're judging that justice is delivered within certain parameters. And for that, the statute in India identifies certain grounds like public policy, patent illegality, and there are certain other grounds which a party can raise. And I just list that very, very quickly. That is incapacity of party, invalid arbitration agreement, improper notice of the arbitrator, award dealing with a dispute not contemplated, composition of the arbitral tribunal or the procedure. These are issues on which a party can come to court and seek a setting aside or vacating of the award. Additionally, the statute provides, it says, it's a very interesting addition. It says, if the court finds, so even if the party doesn't flag that issue, and if the court finds that the subject matter was not capable of arbitration and there was an arbitrability issue, or there is a public policy, or it is patently illegal, then the court can interfere. And public policy has actually engaged the Indian courts very, very often because they, as I said, are guardians of justice, public policy, and public order even in dispensing of justice in the commercial field. And in that, they have taken upon themselves to expand the statutory public policy to include issues of contravention of a statute, because there has to be uniformity in the manner in which statutes are interpreted, law laid down by superior courts, and natural justice, etc. I find a parallel in the FAA. FAA is largely on the conduct of the parties, fraud, corruption, etc. And I'm glad to see that now even in the US, there is a growing discussion on including public policy into a ground for setting aside of domestic awards as well. And I would be very glad if some of the jurisprudence that's developing in India, especially by the Indian courts, because Indian courts have taken great responsibility, have very reluctantly and very responsibly, I must say, within the framework provided, very cautiously, have identified certain very limited grounds under public policy, but very, very emphatically, they have defended public policy. So at a later time, I would sometime, if another opportunity is granted by Amity and the organizers, we would do a comparison of public policy as developing in India and an inspiration we could possibly give it to the US that you must include public policy as a ground, because ultimately that is what is the purpose of law and justice. With that, I thank you for listening to my thoughts, listening to my pointers, and thank you, Dr. Jane R. Matthew, Dr. Tomar, for giving me this opportunity. Thank you.
Thank you. Thank you.
Yeah, thank you, Advocate Priya Kumar, for bringing in clarity in terms of the arbitral awards in India and also comparing it with the FAA in the USA. Now, I would like to call on our last speaker for this session, Dr. Nasiruddin Mohammed. He's a faculty at the University of Dubai. He's a qualified legal practitioner in Nigeria and has acquired training in numerous jurisdictions with many years of legal practice across many jurisdictions. He specializes in international arbitration, international economic law, investment and trade, and energy and natural resources law. Now I call upon Dr. Nasiruddin Mohammed to address the gathering.
Thank you very much, Dr. Matthew. So good morning, good afternoon, good evening, but not good night, as a professor. Yeah, so thank you very much, my distinguished panelists. I sincerely would like to thank Professor Mark, Professor Richard, Professor Nanuj, and Ms. Priya. I mean, I have learned a lot from you from this brief remark, which we just started. So without much ado, mine is to focus on comparative business law. And what I intend to present or to propose is how comparative business law can use harmonization as a tool towards responding to COVID-19 as a global pandemic. And the reason why I have chosen this in the context of comparative business law is to make or to present for the thesis that a coherent or a collective response is possible in the light of a global response to pandemic outside the context of business law. So first of all, it is my pleasure to look at this. And in line with this year's conference theme, we have alluded to fundamental concepts such as transnational governance, global development, complex economic interdependence, as all contributors to the growth of contemporary societies. So I'm basing my remark against that background and to suggest the importance and relevance of comparative business law by setting out what I call a coherent business law response to COVID-19. And my thesis is to suggest that a coherent response can be linked to the thesis of harmonization in business laws, but I will beg you not to ask me which business law, because that's a topic of another discussion. Now, like any harmonization thesis, it is generally understood or regarded as a fallback to the impossibility of unification. So we know unification of laws had been considered by many experts as a utopian argument, but we are comfortable with harmonization because of its success story. So harmonization had helped. In particular, it had helped comparative business law. If we look at the context of, for instance, regional integration, and to some extent, globalization of business law principles. We have seen cases such as Convention for International Sales of Goods as a success story of emergence of some sort of global principles. So what I propose in this short remark is, if COVID pandemic had fostered a global response towards adopting common measures in curtailing the spread of COVID-19, why shouldn't there be a harmonious response in a legal sense, where issues arising from the effect of pandemic can be coherently and collectively approached in a harmonious way? So what I'm trying to suggest is, imagine how catastrophic it would look like to any jurisprudence, for instance, if similar fact as presented, for instance, before Indian courts is decided in one direction, and then same facts are presented in Australia and decided by Australian courts in a different dimension, and all arising from the measure of COVID-19, for instance. So this is where I base what I call the appeal to my thesis, that there is need to look at that. Now, undoubtedly, an off-cap appraisal of likely legal issues or issues that could probably be triggered by COVID-19, I mean, talking within a contractual parlance, for instance, we can look at what our last speaker just mentioned, Ms. Priya, which is issues relating to arbitration or dispute resolution. We know lots of contracts have been affected by the effect of COVID-19. So imagine a situation where a contract with no dispute resolution clause is being is kind of proposed to utilize dispute resolution clause in order to mitigate loss or damages arising from the effect of COVID-19. Similar principles such as performance of contract, change of circumstance, frustration, implied terms, and many more related principles of business law are all affected by the emergence of COVID-19. So what I'm suggesting, what I'm proposing is, first of all, I'm not unmindful of the difficulty or even near impossibility of likely consensus to emerge as a common business law response, because we know this is very difficult. But it suffices to suggest that there are reasons to support the proposition. So like any harmonization thesis, there could be appeal to justice or appeal to fairness. So for instance, as we know, if we look at CISG, for instance, in particular, Article 7 of CISG made reference to good faith as a principle. A reference to good faith in CISG, for instance, is an appeal to fairness. If, for instance, the convention provides that parties should observe their obligation or should apply the principles in good faith in accordance with the principles of international trade. Now, the second reason, which I'm basing the coherent or harmonious response, is the need to protect global supply chain. This is more of a pragmatic argument. If we look at how global supply chain had been affected by COVID-19, we know one breach of one contract would have a multiplier effect on other connected contracts within the chain. So these are real reasons why I feel we can have a harmonious and collective response in the same way nation states had responded to COVID-19 almost coherently. So that's my thesis. And I thank you all for giving me this opportunity to make this brief remark. Thank you, thank you, thank you. And I look forward to seeing all physically.
Thank you so much, Dr. Nasiruddin, for a good address. Now I would like to move forward with the session. Rupender sir, could you please share the citations?
Zain ma'am, I believe the screen is visible to you.
Yeah, it is visible. Thank you so much.
Do I get to say thank you very much? I'm really honored by this.
Okay. We would like to award a citation. This citation is presented to Professor Dr. Mark Draper in the keynote session of the International Conference on Comparative Law on Saturday, the 19th day of February 2022. Professor Graeber, an internationally renowned legal scholar on constitutional law, a dynamic personality with profuse knowledge and enthusiasm, Professor Graeber has contributed immensely to this conference by his thought-provoking words. We are extremely obliged to Professor Graeber for sparing his precious time and adding value to this conference. We hereby recognize the contribution made by Professor Graeber and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you so much. If you want to say a word in reply, I look forward to.
My apologies. I don't quite know the procedure. I am honored, and I find this custom wonderful, one I hope in the spirit of comparative borrowing to bring back to my home institution, the University of Maryland. Thank you again.
Thank you so much, Professor Graeber. Next, this citation is presented to Professor Dr. Richard Albert in the keynote session of the International Conference on Comparative Law on Saturday, the 19th day of February, 2022. Professor Albert, an acclaimed legal scholar, spearheads the Learned Society of Scholars through the International Society of Public Law. Professor Albert's in-depth knowledge on constitutional law and his zeal for making the legal academia more diverse and inclusive is evident from his motivating words. We are extremely thankful to Professor Albert for sparing his precious time and adding value to this conference. We hereby recognize the contribution made by Professor Albert and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Professor Richard, if you're there, if you could give us a reply. Is Sir here?
Yes, of course.
Yeah.
Of course. Thank you so very much. This is a touching moment for which I'm most grateful. I'm grateful for other things too, the invitation, the opportunity to learn from the other speakers today, and the warmth that I feel from the organizers and the hosts for welcoming me just so generously. Thank you so very much for this honor. It's been a pleasure to be with you today.
Thank you so much. So next. This citation is presented to Professor Dr. Manoj Kumar Sinha in the keynote session of the International Conference on Comparative Law on Saturday, the 19th day of February 2022. Professor Sinha, an academician par excellence, contributing to the development of international law, a strong upholder of constitutional values and citizenry rights, and a staunch defender of rights to equality, liberty, and dignity. We are beholden by the presence of Professor Sinha for sparing his precious time and adding value to this conference. We hereby recognize the contribution made by Professor Sinha and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. I would now request Professor Manoj sir to...
Thank you very much. Like it's a great honor and it's a distinct pleasure for me that I have been given citation by like an Amity Law School, which is very close to me, and I have been associated with the Amity Law School, and I believe that till date, I have never said no to any program of Amity Law School, and I wish that will continue always. But I also appreciate one thing which I have just noted quickly, and so I was wondering, like, okay, whether all citation will have same word, like, just generally one citation, you change the name, Professor William Gerber, Richard, and Manoj, and then so and so forth. So, but what I noticed, each citation means like, citation has according to like, you thought about it. That's very important, like, in academics. So it also reflects your commitment and appreciation of the scholars. So each scholars have been in citation, has been individually worded, and accordingly it has been said. So wonderful, like, and I salute for the team of the Amity Law School for taking pain for each aspect. So thank you very much. And it's a great honor for me. Thank you very much. Over to you, sir.
Thank you so much, sir.
It's always a privilege, sir, to host you.
Yes, thank you, Sandita. Thank you.
This citation is presented to Ms. Priya Kumar in the keynote speaker session of the International Conference on Comparative Law on Saturday, the 19th day of February, 2022. Ms. Kumar, a practicing counsel with a vast knowledge and experience in alternate dispute resolution, a dynamic personality and prolific speaker, Ms. Kumar has contributed immensely to this conference by sharing her words of wisdom. We extend our gratitude to Ms. Kumar for sparing her precious time and adding value to this conference. We hereby recognize the contribution made by Ms. Kumar and extend our sincere thanks to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Ms. Priya ma'am, if you could say a few words in reply.
Thank you, Dr. Matthew. I'm really humbled by the great appreciation that you've showered on me. And I actually share the sentiment of the other speakers, that this was a great opportunity for me to be in their company. Thank you so much for the opportunity. Thank you very much.
Thank you so much, Priya ma'am. Next, I would like to read the citation. This citation is presented to Dr. Nasiruddin Mohammed in the keynote session of the International Conference on Comparative Law on Saturday, the 19th day of February 2022. Dr. Mohammed, an academician and a qualified legal practitioner specializing in international arbitration. An illustrious personality with profuse knowledge and enthusiasm, Dr. Mohammed has contributed immensely to this conference by his thought-provoking words. We are extremely grateful to Dr. Mohammed for sparing his precious time and adding value to this conference. We hereby recognize the contribution made by Dr. Mohammed and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Dr. Nasiruddin, if you could say a few words in reply.
Thank you very much, Dr. Matthew and the organizers. And my sincere regards to my panelists as well. This is an honor and a privilege. And I sincerely thank you, and I look forward to meeting all of you in person. Thank you very much.
Thank you so much, Dr. Nasiruddin. Now, moving on to the concluding remarks of this session. I had a wonderful experience with moderating the third keynote session of the third annual International Conference on Comparative Law. I think this was one session which we had a bit of difficulty. We had a doubt whether professors from US would be joining or not because of the time gap which is there. But then we were fortunate enough that they did join. I would say before we ourselves did join, we had Professor Mark joining us. Thank you so much for being present in this conference at this session. Now, some of the takeaways from this session would be that one suggestion which did come in was that there is actually a need for a constitution for a new constitution so as to incorporate new rights which are developing. So that's and also onto the throwing light onto the various rules in terms of amendments which is there, and that amendments which are to be made ought to be in line with the Constitution, and also by introducing a concept on dismemberment and how it violates the core of the Constitution. Now, emphasis has also been relied on the transformative constitutionalism, which is there. Now, these were the major takeaways because we had two separate themes which were included. One was on constitutionalism, the other one was on the business aspect. So in terms of the other two speakers, one was on the finality of arbitral awards, which is there. Now, also, one takeaway was that public policy needs to be incorporated, which is actually a requirement which is there. Now, in terms of the session, I would say that it was a awe-inspiring experience and also a thought-provoking one, which actually added quite a few insights for all those who have attended. Now, moving on, I would like to thank each and every keynote speaker who had come at, I think it was fairly a very short notice with that we had informed with regard to the conference also. But then in spite of that, everyone did join and were happy enough to grace this occasion and also sharing their thought process on the various facets of comparative law. I'd like to thank Professor Mark Graeber, Professor Richard Albert, Professor Manoj Sinha, Ms. Priya Kumar, and Dr. Nasiruddin for having graced this occasion and for making this session and also our conference a grand success. Thank you so much. I'd also like to thank our HOI, that's our head of institution who is here, Aditya Thoma sir, for being here. Third, our guests are here. If you can say a few words.
I just want to pay the regards to our very own dear Professor Sinha sir, who always bless us by their knowledge and views. I just want to thank a very big thanks to Professor Mark, Professor Richards, who just being a very last time gap, even able to join us. And I just want to say thank you to Priya Kumarji. Thank you very much. And Dr. Nasiruddin, I just want to say thank, and I like to invite you all with a request that in the next year we will organize the 4th, and we hope that you will spare your valuable time again. Thank you very much.
Thank you.
Thank you so much, and we hope to meet again, hopefully in the physical mode so that we can interact and meet each other. Thank you so much for gracing this occasion and for imparting your knowledge to us. Thank you so much.
Thank you, Jen. Thank you, Robert. Thank you, Mark. Priyaji, thank you. Dr. Nasiruddin, thank you. Aditya, thank you. See you then. Bye.
There's one more thing for us to do, which is for all of the speakers to unmute themselves and to clap for the organizers and the moderator. Thank you.
Thank you, sir. Thank you.
Indeed.
To the technology team, to the organizing team, everyone who's made this possible. Thank you so much.
Thank you.
Thank you, sir. Thank you, sir.
Thank you.
Thank you so much.
Thank you.